Welcome everybody to the first webinar of the 2025 season. And Mike already gave the title, so I'm not going to do that again. Again, I'm Chuck Krugel, moderator this year. We have the same panel that we had the last year. Max Barrick, of a partner over at the Garfinkel Group, Helen Block of the law office of Helen Block, and Amit Bindra of a partner over at the Prinz Law Firm. And we ask that you check out slide number 5 on the PowerPoint, which is our typical disclaimer that reminds you you can't go out and make important business decisions based on what you learned from us today. We're not your advisors or your attorneys, and you're not our clients. This is just really meant to give you general knowledge to help you select and work with your own attorneys or advisors. Speaking of slides, we'll try to track through them or refer to them whenever we discuss it amongst ourselves, content-wise, although you don't have to really track it yourself during the presentation. And we'll point out to you which slides we're talking about as we go on too. If you want to learn more about us, the panel, you can check us out on slides 35 through 38 of the PowerPoint. And if you're attending the live premiere, you can ask us questions. You can send a question to info@financialpoise.com or through the Zoom portal. If you send us an email, info@financialpoise.com, make sure you include the name of the webinar and episode so we could do our best to get an answer to you. And thanks finally to our sponsors, National Law Review. You can find more about them on slide number 3. Type to Learn, which is a digital learning solution provided by Sunburst Digital, and also Max X Asset, a simpler and easier, better way to conduct online asset sales. Type to Learn and Max X Asset are on slides 4 of the presentation. So with that in mind, let's get going. Let's start with you, Amit. Over the past few years, we've seen a real big change, a sea change, in fact, about how state legislatures and the courts view employment agreements, particularly post-employment restrictions like non-competes, non-solicitations, those types of covenants. They seem to have lost favor with law enforcement. What's your take on this, and where do you think our society or the business community is headed with that?
Well, thanks for having me back again this year. And I think for this question, I could probably spend an entire hour just answering this one question. So I'll do my best to be efficient and just be top level. Since 2012, we've seen a trend amongst the state and even the federal agencies. The trend has been to curtail these in different ways. Starting early in 2012, we saw states passing laws that would limit non-competes or non-solicits, these types of agreements, restrictions on trade, or employee mobility, to not enforce these for employees who are low-wage workers. So Illinois passed at that time the Freedom to Work Act, which was a law that essentially banned a non-compete clause for a worker who made slightly above minimum wage. Other states come and mimic those types of laws. So those are traditionally called like low-wage non-compete laws. And I should back up for a second. A non-compete agreement generally just means an employee agrees not to compete against their former employer, and a non-solicit means they would not solicit their former employer's customers or employees. Because these are restraints on trade, courts do look at these a little bit closer. So it's not just as simple as the employee signed it, that's sufficient, because there's an impact on the overall marketplace. So as I was saying, initially these were just to protect low-wage workers. Then states started moving to a trend to only allow them for higher wage workers or executives, folks who may have slightly more bargaining power or who make more money. We saw those trends kind of in the late 2018 or so range through 2022, 2023. And then after that, we kind of saw both state and federal agencies try to just ban these altogether. So Minnesota banned non-compete clauses in the summer of 2023. Several East Coast states tried to. The legislatures in New York and a couple East Coast states actually did pass laws to ban non-competes. Those were vetoed by the governor. And then last year, we saw some stuff at the federal agency level. The Federal Trade Commission passed a rule to ban non-competes that ultimately was held up through an injunction entered by a court in Texas and now is on appeal. The National Labor Relations Board, their general counsel, has issued a couple memorandums on this issue as well, and they've been investigating non-competes more. So I guess the short version to your question is we're going to see, I think, more curtailment. We're going to see more legislative change. What the presidential administrations between Obama and Biden were good about is coming out with research, keeping this in the national conversation, which led to the legislatures passing laws, which I guess is how federalism in theory is supposed to work. Um, but I think moving forward, I think that's going to continue, and we're going to see is more aggressive bans or restrictions coming from the state legislatures. So my takeaway is generally the legal people and the business people should always talk because these restrictions are intended to protect legitimate business interests, and oftentimes those two communities, the business folks and the lawyers, aren't talking because there are probably better ways to protect a company's information or whatever companies are concerned about that may not involve a non-compete agreement. And so that's usually where I push my corporate clients to have their conversations.
Just a quick question to throw out there, but have you seen any trend in terms of how much money, like the salary wise, the threshold?
Yeah, so um, like I said, initially it was really just people who were making slightly above minimum wage. They could have a non-compete, and that's
Yeah.
now changed. So Colorado passed a law that the threshold was set at about $100,000, but that increases each year. Illinois started at 75,000, goes up to 90,000, but Illinois' law also applies to non-solicits. Washington State has a threshold that's similar to Colorado's. Washington, D.C. came out with a threshold. I want to say it's 250,000, or no, sorry, it's
Hmm.
150,000. So we're seeing higher and higher numbers coming out. New York, so the New York legislature banned non-compete clauses. The governor vetoed that. It looked like they were going to come close on a salary compensation threshold. I think the problem ended up being the definition of compensation, essentially, because in New York, you have a lot of finance folks, so they make a lower base, but then they make a lot of overall compensation, or they
Yeah.
may get equity. So I think they hit a snag based on that. But those are the thresholds we're seeing. And to make this, I think, even more confusing, probably for companies, we're even seeing some local areas come out with potential laws. So New York City, for example, introduced a bill last spring to potentially ban non-competes. I don't think we've seen that elsewhere in the country before. So we're seeing stuff at the state level and now even at the city level.
Thanks, Amit. Great answer. Moving on, Max. Let's look at other areas now at a focus in for risk in the pre-employment stages. What do you think are the biggest or costliest areas of exposure for employers in pre-hiring?
It's thanks again for having me back.
Sure.
Chuck. It's good to be back. I think this is my fifth year in a row. So I don't know
Oh,
if I get
wow.
a medal or something, or it's like Saturday Night Live. Do I get a jacket? Um, so I think it's a good question. I think the way to think about that answer is some of this is legal and some of this is business related, right? And I think these things often go hand in hand. I think before you even get to who you're hiring and what the exposure is with them, understanding what you want out of the role and what that person is designed, what that job description and that person is designed to do, and what that ideal person looks like, both their interpersonal skills or their personality and their skill sets, and how they're going to mesh with the rest of your team and how your business functions are answers you want to have before you start thinking about the legal questions. Because if those things are not aligned to begin with and you don't really know well what you're trying to hire for, you don't really understand the job in all its intricacies, you're just looking for bodies to complete tasks, you're going to make some desperate or less informed decisions.
Yeah.
And I think it's a case of process is going to lead to bad outcomes because you don't even really truly know what you're looking for. That aside, and for the reason people are really here, the legal part, I think that goes hand in hand because if you're not really understanding well your workplace, the strengths, the weaknesses, the dangers from a legal and just business perspective, you are less likely to have clear answers, and you're more likely to maybe make a bad hire or make a rash one. I think big picture, you want to know going in, what are the expectations for this role? What do I need this person to do? Where do I, nowadays we have to think about where do I need them to do it? Is this a white collar job where my industry is now primarily hybrid or remote? Or is this something that's got to be done in person? And what effect does that have on things? And setting expectations for the job that way. You also need to think about job requirements and what does the job description look like and making sure that is very clear and what the qualifications are. I think those are areas that can get you into trouble because if you don't have clearly defined expectations, if you don't really know what you're looking for and you don't understand the nuances of your own business well, you are more likely to make bigger mistakes in that area that are going to lead to legal violations. I think one area that is often very, very expensive and can lead to some very high expense very quickly is what Amit just talked about. Not being aware of the impact of potential restrictive covenants in your industry and in the state law, hiring somebody who, enforceable or not, is subject to a restrictive covenant that's going to potentially cause you trouble. And I think when we get to this, one, Amit will probably tell you, because he's the expert on it, that it's often not important whether or not the non-compete is enforceable in the long term. What is more important is how much trouble and expense can it lead to in the short term. And so just being aware of that up front. I think some others are going to talk about it, but knowing your state's laws on ban the box legislation, and at the state level, what sorts of background checks and inquiries you can make about somebody's history, and knowing that stuff at the federal level as well is a quick way to get yourself sued for Fair Credit Reporting Act violations if you're not careful. But also things like how you advertise the job can come back to bite you. You know, if you use language like we want someone who's young and hip and with it and gets certain things, the first person over 40 who gets rejected for that job is going to have a head start in the race for whether or not they can beat you to the courthouse for an age discrimination claim. And I think there's other issues too. You need to be mindful of state and federal pay transparency requirements. Those are quick ways to step in it if you're not careful. And not being mindful of paying people equitably or giving equitable distribution of benefits and job duties can lead to trouble down the road. The other thing I'll mention is you also want to be up to speed on laws dealing with data privacy and how you handle information as you onboard people. This is only going to apply to like 2 states that I'm aware of right now, but Illinois and Texas have laws about biometric data and information. In Illinois, we call it BIPA, the Biometric Information Privacy Act. I'm embarrassed I don't recall the Texas law off the top of my head, but those 2 states in particular have rules about how you collect certain employee information. And so it's always useful to be aware of these things, because these are items you can screw up before this person has ever even set foot in your company, that can expose you to significant liability if you're not cautious about it.
Great, Max. Thanks. So actually, Helen, moving on, Max alluded to a little bit of this, and we're going to get focus more on this with you. Social media, you know, a lot of employers are using that to screen to screen and source candidates. What are some of the laws that we encounter, and who enforces them, and where are we at with this?
Yeah, so that's a really hot topic these days, as I mentioned as you were introducing the question. And this is an area that is continuously evolving. I would say a number of years ago, it started a little bit, not exactly AI, but it was really more focused on social media when it came time to privacy things. So for instance, when folks were interviewing for jobs, I guess employers were asking for their passwords, wanted to get onto like their Facebook pages, LinkedIn pages, and get really private information about them. And there were a number of states that jumped in and basically said, hey, wait, this is an invasion of folks' privacy. You cannot do that. You cannot ask someone for their password to be able to access their social media. You cannot access their private social media. But whatever's out there that you can just essentially find with a Google search is fair. It's fair game. And so when potential employees interview, they have to remember and think about in the back of their head, what is out there? Do I really want to keep on the internet a picture of myself in college, you know, drunk dancing, you know, on a table in a bar, because someone could find this. Now, who knows? Maybe if you're applying for a job at a certain, you know, place, that would show you as someone fun and the kind of person they want to hire. But more likely than not, in a professional
federal
setting,
government.
Yeah, federal government. Right. These days, maybe. I guess being drunk is a better criteria than, you know, DEI. But putting that aside, you know, more likely than not, in a professional setting, you don't want to have a lot of pictures on your private social media that can be accessed by members of the general public in compromising positions. And even if you take it down, sometimes there are ways of finding things. So you really want to be careful what you put out there that is that is open to members of the general public. Now, putting that big caveat aside, employers generally, they cannot ask for your passwords, they cannot ask for this private identifying information. In terms of AI, that is a hot growing area. The Equal Employment Opportunity Commission, or the federal law would basically say that AI shouldn't be treated differently than any other kind of law, meaning, or any other kind of situation, meaning if it has a disparate impact, if the way the AI is used, let's say, ends up discriminating against people of a certain age demographic, gender, classification, etc., that would be a discriminatory way to use AI. But a lot of states have taken it a step further to make it very, very clear what is discriminatory. And so there are states that have come out that have basically said, if you use AI in a way that discriminates, let's say you program the AI for certain information, or it skews in a discriminatory fashion, that is illegal. You cannot do that. And so a lot of states are jumping in to say how AI can be used, how AI cannot be used, deep fakes, and so on and so forth. Certainly, if you're going to take someone's, biometric privacy, biometric information under the law that Max talked about, BIPA, and also in Texas, then you're going to need to jump through a lot more hoops. You're going to need to disclose that you're doing this. You're going to have to get the individual to consent that it can be used. And even if you use AI in interviewing process, like let's say you have like some sort of auto-generated interview process as a first step, there are a number of states that have laws that say this is the kind of interview that an individual is going to have. You have to disclose it up front and get their consent that you can use this technology in the interview. So this is some of the unfolding laws as AI continues to improve and develop.
By the way, just for reference for everybody, the Texas law is Texas Capture Use of Biometric Identifier Act, QB. All these cute acronyms.
Yeah, I wanted to mention one other thing about what Helen had said about this notion of using AI in hiring. I think Amazon actually abandoned that altogether because they realized that there was no way to do it fully objectively, and whatever biases, conscious or unconscious, intentional or otherwise, that the programmers had to whatever sort of algorithm you came up with to instruct the AI on what to screen for, you were inevitably going to find yourself disadvantaging somebody no matter how hard you tried. And you also need to be mindful of, and we're going to get into disability stuff at a later webinar that I encourage folks to listen to, but there are Americans with Disabilities Act concerns too when you do that sort of screening, using computer screens and AI and what have you, because some people have different recognition issues or what have you. So it's just, sometimes human error feels like what you want to watch out for, but other times it might be the safest option.
So
to add to that real quick too, the problem with all of those things from a company perspective, in addition to what Max just said about the business side, is on the legal side, those are going to likely be class or collective actions, because if it's affecting one person, it's affecting many people.
Yeah.
And so it's a much bigger risk of liability. And we've seen those class actions being filed already against companies that are using AI. And a lot of times it could be a disability type claim, but it could just be a age claim or a gender-based claim too. And so that's another huge risk factor for companies that want to use AI in the kind of pre-screening process or hiring process.
Yeah, I was just going to raise that the disparate impact analysis, that if it tends to exclude a certain number, or if it tends to exclude a class of people, more than one, then yeah, I think you're going to have a lot of problems.
Well, the iTutor case, that Chinese tutoring company
about that
locally, they had explicitly programmed the software to actively screen out people of certain ages and genders. So sometimes it's not even a disparate impact. They're actively, somebody's actively screening for that, whether it's the job description I mentioned of, only people under 40 need apply versus just doing it discreetly. You run the risk somebody's going to notice.
And that was under federal law too. I mean, it was so blatant that you didn't even need some of these amendments that we're seeing in state law. I mean, federal law was very clear that this had a disparate impact.
And there are now state laws that have already been enacted and more are going to pop up. Illinois has one. I think New York has a very similar one, and we're going to see more of those state laws being passed by legislatures to kind of curtail the use of AI in the hiring process.
Well, thanks, everybody. Amit, one of the other topics that comes up a lot and has really changed over the last few years is salary history. I mean, it used to be a perfunctory question. Now that's changed. So what's up with that? Where are we at?
Yeah, I want to say about almost half the states have banned it in some way or another to ask for a company to ask a candidate about their salary history. And in addition to statewide bans, there's also local issues. It's kind of similar to what we're seeing potentially with non-competes. There are localities, for example, the city of Chicago, that have banned asking candidates for their salary history. The workaround generally is to ask employees or candidates for their salary expectations. That seems to be okay. But I think there's the legislatures have generally been concerned from a public policy standpoint of keeping a candidate tied to what they were making before. And so the salary expectation question is safer, but it is a kind of a middle ground because it allows a candidate to then say, this is what I'm expecting, and they can allude to what they were previously making or whatnot. But it still allows the potential employer to get a sense of what the candidate is going to require for the role.
Thanks. Max, increasingly employers are also restricted about asking about criminal convictions and criminal histories. And they must wait until, or generally now they have to wait until they make a conditional offer or select the individual for an interview. What's the conditional offer, and what does this all mean for employers in terms of checking out criminal histories?
So the way to think about a conditional offer is it's an offer contingent on or based on your ability to complete certain tasks, like, hey, if you can do A, B, C, or D, however many steps they throw in, this job is yours, but you need to pass these requirements. So an example might be you want to be in a youth serving organization and work there. And there is a tangible connection between your criminal background and the safety of the children. They can say, hey, to be a teacher, to be the camp counselor, to be the daycare supervisor, what have you, you need to pass a criminal background check and make clear that you are not a risk to these children. Should A, B, or C come up, you may fail and the job offer will be withdrawn. State laws, and in some cases, I think the classifications of certain drugs at the federal level are changing, but there are still certain jobs where certain substances can't show up in your system. So it may be you've got to pass a drug test. For example, Department of Transportation covered truck drivers who do over-the-road truck driving are subject to random drug tests at various points. Proving that you have credentials. It doesn't always have to be passing a criminal background check. It can be other items attendant to your history or your qualifications for the job that you need to satisfy in order to get that job. To the second part of your question about what that means in terms of these background checks, it means you need to, it's another set of laws you need to be mindful of. If safety or background checks are necessary in your industry, because maybe you are a government contractor, and in order to keep your contracts, you have to abide by certain qualifications to employ folks in order to keep those contracts with like the Department of Defense. Then that means you need to be, or you're youth serving or any other reason you're going to background check people, then you need to be aware of state and federal laws on criminal and other items in people's background checks, and what the consequences of not making proper disclosures of that can be, because otherwise you can find yourself running afoul of state law or federal law. As an example, in Illinois, and I've heard this straight from the horse's mouth at our state agency for investigating discrimination, the Department of Human Rights, they and employers are kind of pulling their hair out because a lot of employers have not gotten up to speed on Illinois' new ban the box background check law. And so what ends up happening is you ultimately, a lot of the time, are allowed to do a background check and make the job offer contingent on passage, but there are steps you have to follow, and it's a case of either you did it or you didn't. And so, a lot of employers find themselves frustrated because had they followed the law and the steps correctly, they could still deny somebody with a certain criminal background a job offer. but because they didn't check a certain box and do it the right way and give the person notice of what they were going to do and the opportunity to self-report or explain themselves, whatever the specifics of that law require, they find themselves in violation of a law that they could have used anyway had they just known the steps correctly. So that's a little vague, but it's just a way of saying, if you're going to check people's background like that, you need to know what the state and federal requirements are. You're going to find yourself getting sued over somebody you could have denied the offer anyway.
Thanks, Max. So, Helen, continuing with that line of thinking, I mean, what are these steps? You know, that like Max referred to. And what should the employer do? I guess from logically speaking.
So first of all, you have to look and see what kind of job it is. And so the requirements, let's say for a job for someone who's going to work in a warehouse packing widgets, it's going to be very different than someone who, let's say, works in a daycare center, or who works in customer or client facing roles like in a store as a salesperson. And the reason why I say that is because a lot of these laws actually make it a criteria in terms of even when you can legally ask about conviction history. It really has to be tailored to the kind of a job. So if really, it makes no difference if someone had a certain kind of a criminal background for the job, then you might not even be able to ask it at the outset. So from the outset, you first have to determine what is the kind of job that I'm asking this individual to do.
Mhm.
And does the fact that this person, if the person has or doesn't have a criminal background, does it affect the place of employment? So that's like an inquiry at the outset. The reason why you have to make that kind of inquiry at the outset is, first of all, in general, you cannot have a blanket question on a questionnaire, even asking someone if they have been convicted of a crime. So we're only talking in general about convictions because a lot of states don't even allow you to ask about arrest records. So arrest records are in general illegal. So we're not even talking about arrest records.
I'm
We're
not
talking
even
really
aware.
about,
Just signing up. I'm not even aware of any states that allow arrest records. Period. So.
right. So you can't even ask someone, for instance, if they've ever been arrested. So first of all, on job applications, you're not going to ask any questions about have you ever been subject to a conviction or not. That would not even be an appropriate to just basically use that as a sieve to weed out some people. So you have to wait to the point where you're actually interested in hiring an individual. They've essentially, you found them essentially qualified for your job. Otherwise, they have the skill set, you're interested. At that point, you can then, if it is tailored to the kind of job that it is, ask about criminal convictions, or even tell people. There's nothing illegal about telling someone as part of an interview process what the criteria is for the job. No different than anything else. So for instance, if you have a lifting requirement for your job, you can tell people, even when you advertise a position, that in order to be qualified for this position, here's the criteria. You have to have, certain ability to lift, cannot have been convicted of, certain crimes within the last however many years. So you can't let people know that from the outset. The difference is you can't ask that person until you are ready to actually make a job offer. So once you're ready to make a job offer, and the conviction history would then be relevant for that kind of a job. So for instance, in a daycare situation, criminal history is definitely going to be relevant. And if you don't ask about it and you don't get that information, you could actually, open yourself up to liability for negligent hiring. So even in some place of employment, you really would be remiss if you didn't ask about that. So when you're ready, you got to disclose to the individual that you're going to have to go through the background check. You're going to get their consent to go through the background check. And then you are going to run a background check. And if it comes back with, let's say there's a conviction or something in that history, under the Fair Debt Credit Protection Act and under some various other laws that might be relevant to the state, you got to share that information with the individual, give them an opportunity to contest it, clarify it. And then you go forward with basing your decision on whether or not you want to hire that individual once that information becomes out and you've followed all these various steps to legally conduct a background check when you are allowed to do so.
And I'll throw this out to any of you, but regarding the allowing them to rebut or provide a statement, I mean, do you have to wait in limbo to fill the position while they respond, or why you considered it?
I mean, I don't remember off the top of my head the exact amount of days, but you are supposed to give an individual a certain amount of like a few days or whatnot to come back and provide some sort of response. And they have the report, so they can go contest it on their own. I mean,
Yeah.
perhaps there is some erroneous information on there that needs to be clarified. Maybe, two people have a social security number that was very, very similar and the numbers were transposed. I mean, things like that happen all the time. So, you do want to share with that individual, you have to share with them by law that criminal background check, tell them how they can contest it if they want to contest it. And the fact that they can, respond, but you don't really have to hold the job open for, a certain period of time. And then something interesting I'll just throw in. I mentioned before that you can't use arrest records, and you can't. You
No.
legally can't. But what oftentimes companies will do is that they have policies against bringing, let's say, disrepute to the company. They expect you to have a certain level of professionalism. So oftentimes that's a way to backdoor in, let's say, an arrest. Because let's say oftentimes when someone is arrested, it becomes a public record. It could be in the
Yeah.
news, it could be in the newspaper. And so companies will often say, we're not using the arrest records. There's nothing to do with that, but we've conducted an investigation. It seems like this individual did X, Y, and Z, and that would be against our policies that they engage in this kind of conduct. And again, it's nothing to do with the fact that they were arrested. But you know what? If they weren't arrested, you never would have known about it. And so that is a little bit of a fine line when companies do kind of engage in that kind of practice. So I would say you better conduct an investigation, a thorough investigation, and not just rely on some newspaper article that sees the individual was arrested, because otherwise you could find yourself in hot water and have a claim filed against you for taking an adverse act based on an arrest record against that employee.
All right. Thanks, Helen. Amit, taking this, the background screening and criminal screening from a different dimension or from a different perspective. A lot of employers use third parties to conduct background screening, criminal background checks, that type of stuff. What kind of due diligence should an employer take before engaging one of these companies?
I would say a lot, because the problem an employer can have is if the background check form or whatnot that is being used by a third party company doesn't comply with, let's just say, the FCRA or state law, then it opens up the employer, not just the background check company, to liability.
Fair Credit
So
Reporting Act, FCRA.
yeah, yeah, and so the Fair Credit Reporting Act, and that type of claim, to go back to what we were saying earlier, it's not going to be just like a single individual type claim. It's going to be a claim that's filed on a class basis, because it'll have affected several other either actual employees or candidates or whoever. So companies have to be very careful that the form they're using, the policies they have, are all correct and accurate, regardless of if they're getting them from a third party. There are potential protections they could take. They could include some sort of indemnification language, etc. But short of that, they just have to make sure their paperwork is correct. And Max alluded to this earlier with BIPA, the Biometrics Privacy Act in Illinois. That's another act where a lot of times payroll companies would take on would require the collection of biometrics, but not provide the necessary forms for employees to sign or the necessary consent information. And so what ultimately ended up happening is the employer was on the hook for failing to comply with those laws, even though it was their payroll company who was providing them with the technology. So it's the same issue here. The employer should double check with their own counsel to make sure all the forms are compliant with state and federal law.
Yeah,
Great.
and something just to add on to what Amit was saying, not all background companies conduct the same level of background checks.
Yeah.
And so you have to be careful of that, especially if you are in the kind of industry that needs heightened security. Like, let's say a bank where you're going to have access to certain information, or childcare, or teacher, or that kind of an environment. Because, for instance, I had a client one time that did have a conviction. It was a really low level conviction. It was something that could be wiped off the individual's record within, let's say, 6 months or whatnot. And the person was looking for a job. And so had a friend that had this certain kind of business that often runs background checks. And this individual ran a background check on themselves using this friend's company, and this conviction did not come up. The person decided, you know what, I'm going to go and I'm going to interview for the job. And as part of the interview process, was offered the position subject to the check coming back. And when that company ran the check, it did show up.
And that's always a real concern is the depth and the accuracy thoroughness of these companies.
Yeah.
Some of them are fly-by-nighters.
Right.
Well, thanks, Helen. Um, Max, continuing this line of thought, and I think you sort of touched, it may have been you or Helen who touched on this before. Um, if an employer is going to screen employees, do they have to screen all employees? Can they only screen some of the employees? Is this differential treatment? What's your take on this?
So, it's interesting. I think in a non-employment law setting, a lot of people might say, oh, well, you want to treat everybody equally, so subject them all to the same exact steps, right?
Yeah.
But, I don't think it takes a ton of imagination to think of two people who can work for the same company, private employer in particular, where their jobs are so different that the background check, confidentiality, and other requirements do not need and really shouldn't be the same. So, for example, take somebody who works for a bank. If the bank has rules about, for example, regulatory requirements where people can't be in a certain financial level of distress, or they might do something dangerous with money, or they can't have certain criminal convictions, like you can't have a gambling history, and I'm making this up, but something like that, okay, maybe the tellers shouldn't do that. Maybe the executives making decisions about the bank should, but do the custodial staff really need to be that clean too? Do the greeters at Walmart need to be subject to the same requirements as the pharmacists? And I bring that up because there are situations where, I think, Chuck, you used the term disparate impact before, but essentially a facially neutral policy, a policy that on its face applies to everybody, but in practice has the effect of discriminating against a certain group, can, these neutral policies that get applied across the board, if used incorrectly, can actually be the source of that exposure for you. So I think the long answer to the short question is you need to be mindful of your business. If everybody there needs to observe the same or have the same clean background for safety reasons or other reasons that are attendant to the business or regulations, then yeah, you can do it across the board. But if there's no good reason other than you want to screen for a type of person, and I use type in quotes in a bad way, like you're screening for a certain minority group that might be disparately lacking a certain educational component or subject to criminal convictions, something like that, by applying it across the board, you might actually be more likely to create possible liability for discrimination or improper background checks. I think the other takeaway I'll mention is think about your business considerations, because those two are going to go hand in hand with some of the legal ones, and you may need those to justify why you're applying a policy a certain way. So I think you really do want to think about the business needs and whether it's dangerous for you to be going that way.
Great. Thanks, Max. Helen, taking a different turn now, or changing gears. Job descriptions, are these important? I mean, I think we already answered that earlier on, but why are they important, and what goes into making them? Can you give some examples of what a bad job description or what a good job description is?
Yeah, sure. So in terms of job descriptions, it really depends on the company. It depends on the position. So for instance, if you have, let's say, a very high level type of employee, like a C-suite executive, you might want to outline exactly the job, the criteria. The job title is going to be very, very important to that individual. And so if it turns out that, let's say, in that type of person who you've hired, you also have some sort of, you've negotiated as part of their employment agreement, some sort of exit package, that if, let's say, they are, the title materially changes, or the kind of work they materially change, and it turns out that they ended up doing work that's not within their job description, that could give them an opportunity to, have good reason to get out of the job, and to trigger that kind of severance. So sometimes the job descriptions can be really, really important from that perspective, because it could open the company up to certain liability. Another way that sometimes descriptions can open someone up to liability is if they're written in a discriminatory fashion. So for instance, you have someone who works at, let's say, like a staffing agency or something, and there's some language in the job description that, no matter what, you always have to follow what the client wants and get the kind of candidate that our clients want, our customers want. That might not necessarily work to your advantage, because maybe what the client wants is they say, just send over some cute girls, or send over some big men, or no Hispanics, or no blacks. And you have a problem based on that job description, because you have drafted it in such a way that it could have a discriminatory impact. So that's why the job description can be very, very important, depending on the kind of position, the kind of company. And, and a poor job description can lead to confusion, can lead to folks being upset and disgruntled at the workforce, especially if the job description doesn't exactly match what the person's going to do when they start their job, and they rely on that job description at the time of hire. So yeah, job descriptions are usually important, and it's usually important to get it right.
I got something to toss in there that you raised, Helen. Just can you ask for photos? Hey, send me a photo or a video.
In what context? Because it depends on the context
Well,
again.
that's yeah.
I mean, are you asking for all job candidates because there are so many people that you are interviewing that you're going to, when you write down your notes, maybe you forgot who they're going to be. So you rather have a picture so you can put it and attach it to their application so you can remember who it was that you interviewed. If you can show that is one of the reasons why, because there's such a pool of candidates that you're interviewing, and it would help you to trigger your memory as to who said what, sure, ask. My educated guess is, in today's day and age, you can easily find a picture by going on LinkedIn or going on Facebook. But if it turns out, let's say there's a candidate who, for whatever reason, doesn't have a picture on LinkedIn or Facebook, you could say, hey, would you be able to submit a picture along with your application? You just better make sure to do it in such a way that it doesn't have a discriminatory impact. I mean, you're looking to see if, let's say the person has a gender neutral name, and you want to see, are they really male or they're really female? Because you really only want to hire females and not males, or vice versa. Then no, don't ask for pictures. You're only going to get yourself in trouble. I mean, you shouldn't even have a job unless it's like, let's say, hiring a person to work and clean a bathroom or something, like the fancy restaurants or whatnot that have an attendant in the bathroom. Unless it's job specific, there really shouldn't be any sort of gender type criteria. So my instinct says, oh my God, why are you asking? That could really not be good. But there could be some situations where, if you could give a facially neutral reason, and it doesn't have a disparate impact, there's nothing technically illegal about asking for a picture.
Thanks. So Amit, changing gears again now. Classification issues. A lot of employers like to use independent contractors as a way to save money, escape payroll taxes. What are the key factors an employer should consider when deciding whether to use an independent contractor versus an employee? W-2 versus 1099.
Yeah, I think this is another question where I could probably talk for an hour.
Yeah.
And Max and Helen can too. I think
We'll
ultimately
get into this in other
another
webinars
presentation too. Yeah. So I think ultimately this is short-sighted thinking to do this solely for payroll tax purposes, because if a company gets it wrong, it's again going to be a very big impact. It's going to be a situation where there could be a collective action being filed where someone files on behalf of all employees who are misclassified. And that could be an astronomical monetary hit if those individuals are owed overtime wages. In addition to that, state and federal agencies can get involved. So the State Department of Labor, the Federal Department of Labor, unemployment, workers' comp, they all want their cut of everything as well. And so they have an incentive to look into companies that are potentially misclassifying individuals. The part that gets confusing, I think, for companies for this is that each of the agencies, each of the jurisdictions, courts, et cetera, kind of apply different tests to determine whether someone is really an employee or are they really a contractor. And then even within those tests, even if someone is an employee, there's different tests to determine if someone is eligible for overtime or not. The simplest way for me to think about this process is, is the individual a truly independent business? It's almost like if I'm a law firm and, the bathroom breaks, we hire a plumber, or if the copier isn't working, we hire a copier. The essential the services we perform are law services. But if we hire someone who's a contractor, they would then have their own business. They would be doing something completely different than what we do. I generally am conservative on this issue. I think if it's close to the line, it's better to classify the person as an employee and to treat them as such, just to be on the safe side. Other people I know obviously are going to have a different perspective on that, but I think my conservatism comes from if a mistake is made in this space, it's going to be a very, very big headache.
Pay attorney's fees, the opposing counsel's fees.
Yeah, interest penalties. And again, like, if a whole group of folks are misclassified and are owed overtime, maybe they're not owed a lot of wages, but those add up when it's 100 people, 50 people. And to your point, there's attorney's fees, there's interest penalties, there's a bunch of other things that get tacked on. And the government or agencies also do audits, and those are expensive to deal with. So I think most companies realize it's really not worth it to save a couple of bucks on the payroll taxes if it's going to lead to a huge lawsuit or governmental agencies conducting a bunch of audits.
Well, the most
by the way-
expensive, oh, sorry.
Going back to the biometric Privacy Act stuff, I'm dealing with a case right now where the damages are like minuscule compared to what the attorneys are trying to get.
Yeah.
So,
Yeah, what I was gonna say is that if you are gonna play these games and it is on the line, the one thing you definitely are going to have and you should have is workers' compensation insurance, because that is the one that will bankrupt your company. And also you can be held personally liable for not having workers' compensation insurance. So the entity, the corporation, the LLC is not going to shield you from personal liability. That is the costliest mistake, and that is the mistake that actually can bring the business down.
And typically what happens is one of two things. Either someone is classified as a contractor and wants their overtime wages, or one of three things happen. They want their overtime wages, so they make a report with the Department of Labor or go to an attorney. That leads to then potentially a class or collective action type thing and maybe an audit from the Department of Labor. Secondly, someone gets terminated, they lose their position, they want unemployment. Then unemployment looks into it and they conduct an audit. Or third, what Helen just said, someone gets injured. Obviously, they want their medical bills paid, they have an injury, etc. And then that leads to a huge problem and headache. And then that last headache leads to all the other headaches too. Because if someone makes a claim for workers' comp, that may then lead to other claims for overtime wages, etc. Because now people are just looking into it. So these costs also compound as one of these situations arise.
Well, and to build on that too, there's another factor, which is the IRS as well, because there are certain industries. I mean, of all the agencies on heaven or earth that I think most individuals and companies fear, I think the IRS is usually first, second, and third on that list. And in certain industries in particular where, let's say tax shenanigans may be rampant and misclassification is rampant, like say the trucking industry, open road trucking, I'm fairly confident there's IRS guidance that says as a baseline that drivers are not supposed to be classified as 1099s, even though like a huge chunk of these businesses misclassify them that way. You can end up owing back taxes to the IRS on all this, and there could be other penalties as well. And chances are, if you're not being terribly cautious about how you classify and pay taxes on employees, you may also be doing other things under the table that the IRS might frown on. And once their claws are in and they're looking around, what's to stop somebody from uncovering other things? So this is not me telling you hide your bodies better. It's saying be very careful about misclassifying people, because like Ahmed is saying, the consequences can be across the board in legal and financial and regulatory.
So Max, let's stick with you on this and with classification. Another classification issue that comes up is the exempt versus non-exempt from overtime classification. So what are we talking about there? What laws and how should an employer go about determining whether a position is exempt or non-exempt from overtime?
Flip a coin. No, don't do that. I'm kidding. So the
Some employers do that.
That might be better than some employers I've seen on the plaintiff side do it. Some of them don't seem to care. No, I think the main law you're going to look at is the Federal Fair Labor Standards Act. That is the law, and I think somebody else mentioned it. It's the law that gives us the 40-hour work week, the minimum wage requirements, and the requirement for time and a half for overtime. And it is one of my favorite federal laws as a plaintiff's lawyer, because there is just simply so much material out there to navigate it that you really do not have to be an attorney to use and understand. The U.S. Department of Labor has a barrage of really helpful guidelines on this exact topic and what we call different exemptions. And I know there's a wage and hour webinar coming up in a few months, Show Me the Money, I think we always call it. But we're going to talk about this. But the DOL is so helpful because it gives you so many different, it's not just, okay, these are the requirements of these different exemptions where if somebody falls into these categories, that, for example, the white collar exemptions like administrative employees, executive employees, certain sales employees, that sort of thing. Your job may be by law exempt from overtime requirements, but it's not, the title is not what matters. It's going to be, how is this person paid? What are their wages? And what are their job duties and the measures of authority that they have? And then depending on the exemption, what industry you're in. So I would encourage folks to look at the Department of Labor guidelines on that. And at the state level, a lot of states also have robust laws in place and regulations that people can use. But you really do want to be cautious about this. I was once referred a client who had a small bonus claim, and I was this close to rejecting the case because economically it didn't make sense for him or me for us to get involved. And I asked him one more question: how are you paid? And this person happened to be a dispatcher at an over-the-road trucking company. Over-the-road truck drivers and safety affecting employees fall into what's typically referred to as the Motor Carrier Act exemption. Basically, genuine safety affecting employees and drivers are paid based on Department of Transportation guidelines, not the Department of Labor's. But there's an exception to that exemption, and that is, for example, for dispatchers. And not only do these regulations exist, but the DOL also has what's called fact sheets that walk you through in lay terms how these exemptions work. And the fact sheet for the trucking exemption, and I think maybe the administrative one too, flat out says dispatchers are not part of this exemption. So what was a $5,000 bonus case against this company turned into, they ended up resolving it for close to $200,000 for what's called a collective of dispatchers who, had they simply given them time and a half for the Saturday work they were making them do, they never would have had this problem. But because of the strong wage laws in our state, and just the per se violation of these federal wage and hour laws, not only did they owe that to my clients and my firm, but they also had to pay their own lawyers for a good year and a half to fight this case, and get them there. So you want to be real cautious about this. And I think Amit's suggestion was very apt. If it's a close call, strongly consider erring on the side of paying the overtime, because the downside is so draconian for businesses, it really may not be worth it.
Same with classifying as an employee versus independent contractor. Yeah.
I mean, it's the same analysis, right?
Yeah.
Like, you're gonna get hit by the same laws.
Great. Helen, defending to hire claims. This is another area of litigation that's complex and incredibly expensive for employers. If an employer is going to cite lack of qualifications for the reason not to hire, how should an employer go about screening, like what's typically called like KSAs, knowledge, skills, and abilities?
So this is something where you really have to act kind of uniform in your interviewing and screening process, because you don't know at the end of the day who it is that you're not going to be hiring, who then can potentially have a claim, who will say, you didn't hire me because I'm a member of a protected class. And because you don't know the end, you have to start at the beginning, very, very conscientious. So if you ask very similar questions to all the people who you're interviewing, if you mention that you have the same criteria for the job, you take notes as to what different people said. So this way you have a way to refresh your recollection. So if someone does, let's say you do get a demand letter saying, hey, you didn't hire my person because they're a member of such and such protected class, you can go back to your notes and you can say, well, that's not true at all, because I asked this person X, Y, and Z, and they didn't really give such a great answer. You will have some criteria that you can use to rely upon to support why you hired A instead of B. So, that's a really great way to try to hedge your bets essentially against a potential claim for a failure to hire. So again, the person should meet, if you have certain criteria, they should meet your criteria. Now, again, not everything is black and white, and it could be that someone is just interviews so well that they, just knock you off your feet, and you decide to say, okay, fine, they have a bachelor's, not a master's. I really would have preferred someone with a master's, but this person is so intelligent and so sharp, and they were so quick on their feet. You know what? I think I can get away without having someone with, let's say, a master's, and I can just deal with someone who has a bachelor's. It turns out they have like 10 years of work experience, and all that work experience, makes them qualified more so than, let's say, someone, if they did have the master's. So yes, individuals are not always going to be uniform, but if you do have some sort of uniform criteria as to what you're looking for the job, it would help you hedge against a potential failure to hire. So again, the best things that you could do in terms of failure to hire is have specific questions that you ask everyone, take notes so you know what people said, and you have a rationale for your reasoning as to why you hired, one person as opposed to another. Not just that, have everyone submit the same kind of material. So if, for instance, you ask for a resume, you ask for a cover letter, you ask them to answer certain kinds of questions, make sure everyone does that. Don't do that for most people, except for, your best friend's kid who you feel you owe a favor to, that you decide to hire, and all they have to do is just, call you on the phone. Even if you are inclined, let's say, to hire that person, make sure they go through the same criteria. They've submitted their resume, they've answered the questions, the written questionnaire that you want them to answer, that you are able to say, on paper, they fit the criteria.
Thanks, Helen. Coming up to the top of the hour, let's see if we can get through this one. I'll throw this out to all of you. Getting back to employment agreements again. So if a candidate discloses the existence of an employment agreement, what do you do as an employer? And also, I mean, we know that you should ask them if one exists, but what if they disclose it to you?
Ask to see a copy of it.
Yeah.
You want to see if there's anything that they have in writing that precludes them from working at your company, or maybe it doesn't preclude them from working for your company, but maybe it precludes them from working in a specific sector, or with certain kinds, or in a certain geographic area, or with certain kinds of customers, or with clients. They could be subject to a non-compete or non-solicit from their prior job, and you don't want to find yourself in a lawsuit with their former employer that they've stolen confidential information, brought it to your company, and then you have to defend against such a claim. So if you are put on notice that they do have perhaps prior restrictive covenants with a prior employer, you want to get a copy of them, you want to look at it, and you want to analyze it.
Here's one I'll toss out. A lot of these agreements, employment agreements, have like a mandatory clauses, like, changes can only be agreed to mutually in writing. I mean, if you're an employer who finds out about a restrictive covenant, do you call the other business and see if you could amend it?
Yeah, there's a couple different approaches there. You could have the employee do it and see if they can kind of get some sort of waiver from the employer so it's not enforceable. You could do a business to business type of call, like maybe your company's CEO or executive calls one of their people to see if you can get some sort of waiver. And to Helen's point, you could maybe make a determination of like either A, this is not enforceable, and so we're comfortable with the risk, or B, where there's three approaches. B, it's you can work around it. Like maybe you can hire the candidate without actually violating the covenants. Or C, you assume the risk as part of the business deal you built in, and then you're just going to pay for the legal fees to bring the person over.
Interesting. Helen, you were going to say something?
I think Amit summed it up pretty well.
Well, thanks. Hey, well, thanks, Amit. You shut everybody up.
Sorry.
He has that effect on people, Chuck.
So, all right, we're done with this one. We're going to be back for our second webinar of this series. That'll be Ounce of Prevention Policies, Procedures, and Proactivity. That's on February 27th at 2 p.m. Central. So thanks, everybody, for showing up. Thanks for attendees, and thanks for the panelists. Take care, everybody, and see you on February 27th.
Thanks, Chuck.
Hey, everyone.
Thanks,
Thank
everyone.
you.